Hello and welcome to the second in our series of webinars given by the Commercial Division at 5Paper. My name is Morwenna and I'm a barrister specialising in insolvency law. The ICC judges have recently given some criticism as to how insolvency applications have been prepared. So this webinar will consider what those criticisms are and seek to address them, looking at the practicalities and pitfalls in preparing insolvency cases. So first of all, let's consider insolvency applications in general. As you all know, applications in insolvency proceed by way of application notice and a witness statement in support, although in some situations the court can later make directions ordering for pleadings to be produced, particularly where the issues are complex or there are serious allegations such as dishonesty. But for the most part, they proceed by way of application notice and witness statement in support. And these are not pleadings. And that was held in the case of Port and Auger. Therefore, as they're not pleadings, they can't be struck out pursuant to CPR 3.4, although the court does retain its inherent jurisdiction and is able to strike out an inadequately pleaded case. The case must set out what relief is sought and the evidence relied upon. So what does constitute an inadequately pleaded case? A recent case considering that was Ligo and Hunt, a case from last year. In that case, it was stated that it is unnecessary to exhaustively particularise the case at the outset, particularly where pleadings may be ordered later. If the other side alleges they're inadequate, then it would usually be sensible and fair to allow the applicant to elaborate the case or for the court to order pleadings produced. Dishonesty must, of course, be clearly set out and particularised, and of course that is also a requirement of the Civil Procedure Rules and the Chancery Guide. In Ligo and Hunt, it was a Section 423 claim, which also involved allegations of dishonest assistance and sham. The application was made by the second respondent, who was the bankrupt's son and a director of a recipient company, to strike out the case as the pleading was inadequate, particularly bearing in mind the allegations of dishonesty. In that case, it was held that the application notice and accompanying evidence must be considered together. They must set out the facts that underpin the application and the causes of action that arise out of those facts. The court looked at the overall package of evidence as presenting a pattern of dishonest behaviour. So in that case, the application failed both at first instance and on appeal. The case was not struck out. It also concerned an application to amend to bring a dishonest assistance claim and conspiracy allegations. These were new and limitation reasons. The court therefore needed to consider whether they arose out of substantially the same facts. They did. That underlines the importance of setting out all relevant facts that may be relied upon. So how best do we prove our case? The documents are considered the best evidence, and there's been a real shift in the courts in recent years to preferring contemporaneous documentary evidence or any objectively provable facts over the mere recollection of witnesses whose evidence can be fallible. There's a particularly good passage in the case of GSC, BM Bank and Capeman in 2018, paragraphs 67 to 69, which sets that out. It stated that it's now widely accepted that memories are fallible. People can convince themselves of the veracity of false recollections of events and retain confidence in their false recollection. And a judge's ability to evaluate honesty and reliability merely from a witness's demeanour is also fallible. And therefore, where possible, a court should rely on documentary evidence and any other objectively provable facts. When considering the credibility of witnesses, it's always important to test their veracity by reference to the objective facts proved independently of their testimony, in particular by reference to the documents in the case, and also to pay particular regard to their motives and to the overall probabilities. Where there is a lack of contemporaneous documentation, it's necessary to have regard to the inherent plausibility or implausibility of witnesses' accounts. And it's important to consider the whole of the evidence. So looking at that in the context of insolvency, a fairly recent case of Guardian Care Homes West Limited did consider how best to prove the case. That was a TUV and misfeasance claim brought by the liquidators against the directors and proceeded by way of pleadings with directions for witness statements of fact to be exchanged. And that's important to remember because obviously that's slightly different to the usual scenario in insolvency applications. Judge Barber in that case was really quite critical and decided to exclude the witness statement of the liquidator, although she did allow the exhibits to remain in evidence. She held there was no direct factual evidence on the issues pleaded in that witness statement. The liquidator herself had carried out no investigative work, and the liquidator's own interpretation of the documents was a matter of opinion only. She was also critical for the failure to give the source of factual assertions. I will quote in particular paragraph 19.3 of the Chancery Guide provides that a witness statement should be confined to facts of which the witness can give evidence. It is not, for example, the function of a witness statement to provide a commentary on the documents in the trial bundle, nor to set out quotations from such documents, nor to engage in matters of argument, expressions of opinion or submissions about the issues, nor to make observations about the evidence of other witnesses. Paragraph 19.4 of the Chancery Guide goes on to confirm the long-standing principle that witness statements must indicate which of the statements made are made from the witness's own knowledge and which are made on information and belief, giving the source of the information or basis for the belief. The criticism in that case was Miss Wade, the liquidator, her statement set out at length her own interpretation of documents. Such interpretation is a matter of opinion only and is of no real probative value. It also contains factual assertions for which no source of knowledge is provided. This is unhelpful. I would add that at times the prose reads as if the statement was a pleading. The statement also contains allegations which, on their face, differ from and go significantly beyond those set out in the points of claim. So that is really instructive about what not to do. Although we do have some difficulties in insolvency applications because, in a way, the usual applications don't proceed by way of pleadings, and we have this strange amalgam of pleadings and evidence in the application notice and witness statement in support. So that can be borne in mind in those situations. But in a case such as the Guardian Care Homes case, where it's proceeded by way of pleadings and then witness statements of facts, that really is a different matter. So there is a distinction. Where an application proceeds in the ordinary course by way of application and supporting witness statements, The filing of one or more of those statements by an office holder is to be expected, and the court recognised that in this case. However, in a case such as guardian care homes, where pleadings and full disclosure have been directed, office holders should refrain from filing witness statements which do little more than set out their own views on given documents. Still less should they be, by their witness statement, put forward a case at variance with that pleaded. So in that case, the TUV claim failed. It simply did not get off the ground. The court was very critical of the liquidator. They failed to properly plead or define transaction. They failed to evidence value flowing from and to the company, which obviously is important in the context of a TUV claim. You need to set out the consideration and show that there was an undervalue. And they failed to satisfy the court on the balance of probabilities that there was a transaction selling assets, which was later reversed. And the journals relied upon were a shaky starting point. Now, just turning to that, the liquidator very much based the crux of their case on some accounting journals, which recorded a transfer of fixtures and fittings from the company to a third party. And that was later reversed. However, it was important that these were not considered in isolation. If you actually looked at all the circumstances, you would see that the fixtures and fittings remained in situ. As I stated, the transaction was actually later reversed in another journal. And the accountant's general practice was actually that he generally made provisional transactions in the accounting journals, which he later then reversed. Other journals showed this, and that undermined the entire set of journals. It was his practice to do this in a provisional way. He was also unwell as well at the relevant time. So in reality, there was no transfer. It was an error that was later corrected. And the court also emphasised the necessity to consider what documents are indeed absent. For example, there were no board minutes from either guardian care homes or the recipient company relating to this transaction. There were no invoices. So overall, the case had a very shaky foundation indeed, relying upon these accounting journals. The Section 212 claim also failed, and that was based upon the TUV claim itself, so it's parasitic upon it. It was scantily pleaded, and it was confirmed in submissions it was based on breach of fiduciary duty in allowing the TUV. However, that would never get off the ground because no knowledge, actual or constructive, by the wife in that situation, Mrs. H, had been alleged. So there was no knowledge, actual or constructive, of the transaction alleged against her. And that was essential for a fiduciary duty to arise, and therefore there could be no breach. Therefore, the liquidator should strive to gather and review all readily available evidence impartially. They should also be alive to the possibility of conjecture and unsubstantiated opinion. They should re-evaluate evidence as the investigation progresses, and they should properly analyse and accurately plead causes of action. So looking at things with a critical eye is really important when you're preparing your case and putting your evidence together. One needs to really assess what the true probative value of evidence is, both for your case and against it. For example, the journals were a shaky foundation in the guardian care homes case. Also, it's useful to consider matters from the opposing perspective. Are there any innocent explanations? which judges, of course, tend to prefer. It's important to take a holistic view of the evidence and avoid, as in that case, being over-selective. One needs to, when you investigate and prepare your case, look at all the evidence and not go down one particular path with a blinkered view. Beware of confirmation bias, where you tend to just have a case theory and look for evidence that supports that and ignore any evidence that points in another direction. And of course, context is everything. So for example, if you're looking at a £200,000 transfer, in one case, that might be highly significant if, generally speaking, the company or person only had sporadic and small transfers. Whereas in the context of a busy company turning over a large amount where transactions are quite high, it may be less significant. It's also important to reevaluate as the case progresses, particularly before the point of issue and also once one has received the evidence from the other side. And also importantly, you cannot base a positive case on inconsistencies in the respondent's case alone. And that takes us to the case of Wood and Watkin, a case from last year, where the trustee in bankruptcy brought a claim against the bankrupt Carl Watkin and his daughter Kate for declarations and orders for sale against 3 properties which were registered solely in Kate's name. Alternatively, they brought a Section 423 claim. And their case very much hinged upon monies that had been provided by the bankrupt and his friend to Kate, and they relied upon resulting trust principles. This case proceeded by way of application notice and supporting statements, so no pleadings or disclosure was ordered. There was a real criticism in the case, however, as to documentation, and the relevant documentation was not exhibited or otherwise produced in evidence. For example, the PIQ, the transcript of the interview with the bankrupt, and the full set of bank statements, which are of obvious relevance because we were concerning the situation where transfers of money had been made. The office holder merely appended those statements showing those particular transactions, but not all statements giving the whole picture. It was said that office holders must exhibit non-privileged documents of obvious relevance to the issues raised. So that's an important obligation. And indeed, by not exhibiting all the relevant documents, because they hadn't produced all of the bank statements, an inference was actually drawn against the trustee in bankruptcy that the bank statements did not show regular payments of rent from the daughter to the bankrupt's joint account. There was a real concern of the court about selective and inaccurate presentation of the trustee in bankruptcy's case. For example, Mr. Quinn, that other person who'd forwarded some monies, he was described as simply a, quote, business colleague of the bankrupt, painting that as a picture of him somewhat removed from the family. However, the bankrupt had actually told the trustee in bankruptcy in interview that he was also a close family friend, and that put a different complexion on matters. Mr. Wood, the trustee in bankruptcy, knew little of any probative value about the issues arising and played very little part in the investigations himself. So again, another criticism as to the person providing the evidence. Because the trustee relied upon resulting trust principles, there was a need to look at the source of the funding, and that was the joint account of Carl and Jill Watkin. And therefore, there was a presumption that that was jointly owned. Therefore, you couldn't attribute the payments made to the daughter to Carl alone. There was also a presumption of advancement from the father to the daughter. And looking at the whole circumstances as well, it was important to bear those in mind because, for example, family bequests for the benefit of Kate, the daughter, have been paid into the joint account of Carl and Jill, and not then paid out to her. So it was a context of looking at how the family dealt with funds. And also just why the properties were purchased. There was no explanation as to why it was put in Kate's sole name at locations that were convenient to her. So they were bought in locations, for example, where she went to university, when she moved to London, etc. And why that would be the case if they weren't for her benefit. And looking at the case on a whole, the trustee also very much placed great stock on inconsistencies in the evidence of the daughter and the wife. However, those errors and inconsistencies were held by the court to reflect the challenges of remembering payments in family circumstances in the context of this being many years on from when it happened, a long time ago, and who can really remember the intricacies of all of these payments. And that was also compounded by the relevant documents not having been adduced. They didn't have those as an aid memoir. The trustee had not actually produced the full set of statements, which would have assisted them in recollecting what happened. You cannot prove a case on inconsistencies. It was underlined. The trustee in bankruptcy produced no direct evidence of the Section 423 purpose either. And one must remember, obviously, that's an important element in Section 423. There's a mental element which must also be produced. There was no direct evidence, nor was there any persuasive evidence from which to infer such. So looking at that, the context really is everything. One really needs to take a holistic view of evidence, take a step back. For example, you can look at the chronology. In that case, the property was bought at the time that Carl was in no financial difficulty. In fact, he wasn't in financial difficulty for several years after when those properties were bought. So in the context of a Section 423 claim, for example, why would he be seeking to put it in his daughter's name and put it out of reach of creditors at a time when he wouldn't have had any creditors in mind, at a time when he was financially stable? Also, adopting a pragmatic and common sense approach is also important. For example, again, in the Wood and Watkin context, there was no real sense in the case as to why the property would be held on trust for Carl. There was no real reason for it. Everything really pointed to it being for Kate. You know, the locations were handy for her, and she paid all of the mortgage payments and she paid for the outgoings. So overall, common sense, it pointed to them being her properties. And also looking again at this case, looking at the statutory purpose and Section 423, just the overall plausibility of the case is important to assess. A good quote from that case is that it was, quote, inherently implausible that an individual commanding an annual income of £1.6 million would wish to conceal sums of no more than a small fraction of that income. So overall, it's really important, I would say, that you keep in mind the burden of proof to begin with. That is usually on the office holder. I mean, there are sometimes presumptions that can be prayed in aid, but on the whole, it's the office holder to prove their case. Also bear in mind any presumptions that might be used against the office holder. Analyse the causes of action and what needs to be proved. What facts support those elements, either directly or indirectly? What documentary evidence in particular supports it? Are there any gaps? What evidence doesn't support it? and who is best placed to give evidence. It wouldn't necessarily always be the office holder. It might actually be better if it was a more junior employee in the IP firm who's been primarily responsible for the investigations. They can give more relevant, more probative evidence. Is there sufficient evidence overall to properly prove my case? I'll be very happy to take any questions you may have, either by email or by picking up the phone. So please do that, and I hope it's overall has been helpful to you. Please tune in again on Thursday for our next webinar being given live by Roger Leville, and that's on piercing the corporate veil. And also look out next week on Tuesday, the 5th of May, for a further webinar which is particularly relevant again to evidence. It's looking at witness statements in the context of preparing them for trial and the requirements of what you need to address, and in particular the new practice direction. It's important to bear that in mind because there's changes to statements of truth and other matters that need to be included. So I hope that is helpful too. Thank you very much.